back to Winning Isn't Easy. Let's talk about the 10 common mistakes that you can make in your ERISA disability claim. Now, in the course of my practice, I have found that these are 10 common but avoidable problems. And you should be aware of these before you stop work and apply for your benefits. And I'm going to use a case to illustrate this. This is a case of Adams Runyon versus Unum Life. It's a case out of California, and I think it illustrates all of these problems. Now, Adams Runyon was the director of the laboratory services at Doctors Hospital of Manteca, which required her to sit at least 6 hours per day. Her job was very, very stressful, and she had undergone heart surgery in 2015. She successfully returned to work. Adams Runyon was hospitalized again on May 8th, 2018, and after her discharge, she once again went back to work. Her post-hospitalization cardiac examinations were normal. There was no evidence that she was having any accelerated medical treatment or symptoms for her cardiac condition. Now, she stopped working, and of course, carrier's going to scratch their head. But she was having some complaints of dizziness, fatigue, and shortness of breath with chest pain, and that happened about twice a week. Notwithstanding that, she wasn't getting treatment, but she'd undergone a left heart catheterization that showed multiple vessel coronary artery disease. So clearly, when she has these diagnostic studies, she has the catheterization, she continues to report chest pain with emotional stress and fatigue. But after she undergoes this catheterization, her physical examination was normal. And as of January 9, 2019, she advised and the doctor noted that she planned to retire in March of 2019. Now, this wasn't helpful because she had originally had the surgery. She had returned to work without symptoms, had begun to have some symptoms, went in, got a cath. Cath apparently was successful, even though she was continuing to have some symptoms, but she wasn't necessarily getting a lot of care or consistent care. Now, here's where the problems have already started. She told her doctor that she was going to retire. And she last worked on March 14, 2019, and she worked a full day. The following day, she posted on Facebook that she had a new job and it was retired. Boy, that's another problem. Retroactively, her doctor said, you were out of work as of March 15th, and it certainly was on a temporary basis. And then ultimately, she asked the doctor to continue her in the no work status because of the stress of her position. Another set of problems. She told her doctor she wasn't going to die at her desk. She didn't discuss symptoms. She just said she wasn't going to die. Now, according to the terms of the policy, she had the burden of proof. She had to prove that she had restrictions and limitations that prevented her from performing the material and substantial duties of her occupation. And stress generally is not going to be sufficient. Obviously, she applied for her disability benefits, and in that process, she had a call with Unum, the disability carrier. And what did she tell them? She told them that she had been at her Oregon home for at least 3 months. She could drive a car and a boat, and she could use her computer, and she could go out to dinner. She claimed that she couldn't work because she was on call 24/7 and her job was very stressful. Now, there were no symptoms tied to any of this. Unum denies her claim because of the normal examination findings, the lack of consistency in her complaints, the lack of documentation in her medical records, the Facebook comments she made, and the inconsistency between her activities and her allegations of fatigue. Now, Unum also rejected the opinions of her primary doctor because Adams Runyon's records did not record some of the claimed subjective disabling symptoms. And the records didn't explain the basis of the doctor's opinion that she was unable to work. The primary care doctor just accepted Adams Runyon's claim that she couldn't work because of exhaustion and stress. And as a matter of law, that's not going to work. ERISA claims administrators and disability carriers are not required to give any special deference to the opinions of treating physicians. So when a federal court evaluates the credibility and weight to be given to a treating physician's opinion, the court is going to look to a number of things. They're going to look at the extent of the patient's treatment history, the doctor's specialization, if any, and how much detail the doctor provides in supporting their conclusions that the person couldn't work or had restrictions and limitations. Now, the more detail a physician provides for the basis of the opinion, the more weight a court is likely to give to the treating physician's opinion. And this was a huge problem in the case of Adams Runyon. And the federal judge ultimately upholds the denial of the benefits. So let's review here. Did you spot the mistakes? Let's go through them. And I'm going to talk about what should have been done. Well, number one, the policy's medical records don't document the nature of the symptoms and functionality prior to the decision to stop work. Two, the policyholder was working full-time up until the date they stopped working. Number three, there's no explanation as to why the policyholder could work one day and not the next. Four, the restrictions and limitations come only after the policyholder stops working. Five, the policyholder makes Facebook postings that are inconsistent with the claim. I'm retired. Six, the policyholder's post-retirement activities are inconsistent with the claimed symptoms. Seven, the policyholder's examination and diagnostic studies are normal. And number eight, there's no medical support or explanation for the subjective complaints, and there is a lack of medical treatment. And number nine, the treating physician doesn't explain why the policyholder can't work and just kind of repeats and endorses the policyholder's claim that they can't work. And number 10, there really was no planning on the part of Runyon. She failed to hire an experienced ERISA disability attorney who would have reviewed her policy or plan, reviewed her medical records, and would have supplemented the records to provide documentation of her symptoms and functionality, picked the right date to claim for disability, and had an objective correlation between the symptoms and her inability to work as of the date she stopped working. And of course, the attorney would have advised her never, ever to do any posting on Facebook. In this situation, I would have said, stay off Facebook. I want you to go get regular treatment. I want you to document your symptoms. I want you to document how they impact your ability to do the material and substantial duties of your occupation. I want your doctor to provide support and detailed explanations as to why you can't work. And if need be, let's go get an IME or a functional capacity evaluation to establish what, in fact, your functional capacity was and the impact of fatigue. Now, you can see why she lost, and I don't want you to make those mistakes. Think about those 10 things before you stop work. Got it? Let's take a break.